Well, greetings, folks. This is Bill O'Leary, and the topic of this video is going to be probate, and the question that I'm going to answer is probate bad? So you're going to learn three things in this video. Number one, what has to happen to a deceased person's estate after they pass away? Number two, what probate is, and three, the four problems that we see with probate. Just by way of quick introduction, again, my name is Bill O'Leary. I'm an estate planning attorney and elder law probate, and my firm is Legacy Planning Law Group in Jacksonville, Florida. So let's jump right in. Let's talk about probate. So first, let me say this, that when you die, your affairs have to be put in order. That's fairly obvious. Your estate has to be settled. What's also known as administering estate, settling estate, administering estate. They're all the same. And there's certain things that have to be dealt with when settling any estate. First, somebody needs to step forward and be in charge of the estate. And a lot of times this ends up falling on a family member. Now, once that person jumps in, the initial thing they have to do, very first thing, is to figure out what assets the deceased person owned. And this is a process called marshaling the assets, And this could be anything from, let's say, a house to maybe bank accounts, let's say an investment or brokerage account, maybe even life insurance, retirement accounts, that sort of thing. And by the way, this process can take some time if the deceased person did not leave good records, which often is the case. Now, once the assets have been identified, the person that is in charge has to take steps to what's called secure the assets. Maybe that's taking physical possession of a home or taking control of a bank account, investment account, that sort of thing. It's important that the deceased person's assets be preserved until later when they're ultimately distributed to the beneficiaries. Now, after all the assets are identified and secured, that really the next step is to identify any outstanding debts that the deceased person had. Maybe it's an unpaid credit card bill, or maybe a utility bill that wasn't paid, mortgage payment, let's say, that is coming due. Maybe it's an ambulance bill or a hospital bill that was incurred but not invoiced before the deceased person passed away. These debts have to be paid first. And sometimes it takes a while to sort of figure out if there are any unpaid bills. And to make sure that all creditors are identified, there's a legal process to follow where this can be figured out. Give every possible creditor, even unknown creditors, an opportunity to come forward with their claim. The last thing you want to do is to not follow this legal process and then have an unknown creditor surface, months later after the estate assets have been distributed out to the beneficiaries. And I can tell you that creditor would not be happy in that situation to learn there are no estate assets left anymore to pay their bill. And guess what? They will have every right to go after the person in charge of the estate to get the bill paid. Now, after doing some other housekeeping items, one of the things to do is to ultimately make distributions to the heirs or beneficiaries of the estate. And to do this, the person in charge, I should say, needs to figure out who these people are. Who are the heirs? Who are the beneficiaries? Well, if the deceased person left a will, that hopefully should be pretty easy to answer. It's the people listed in the will. Now, if there's no will, what do? Well, the heirs will be determined by the state law. And the state, you see, has a list of heirs. And some heirs who think that they should be on the list later find out with some frustration that they're not on the list. That's why it's important to have a will. So now the question is whether it is better for an estate to be administered, I like to call it the smooth and easy way, or the not so smooth and easy way. Well, I'll ask you this question. Would you prefer the smooth and easy way? I would like to think that you would. And when I ask this question of people in my office, almost everybody says yes. And it's still the occasional person that says no to that question that still baffles me, but be that as it may. So let me quickly point out what the smooth and easy way often looks like. And that's by putting in place what's called a living trust, which is a great solution for a lot of people, again, to achieve that smooth and easy. But the smooth and easy solution that's really a topic for a different video. In this video, I want to focus on the not smooth and the not easy way, and that is called probate. So what is probate? It's a court process whereby a person's estate is going to be handled by somebody on a day-to-day basis, the executor, but with the oversight of a judge, a probate judge. Well, why is that a problem? Why is that the not so smooth and not so easy way? Well, there are 4 problems with probate. And really, sort of put it another way, there are 4 reasons why you should plan to avoid probate. Number 1, time. Probate takes a long time. In my experience, the average length of sort of a formal probate proceeding takes anywhere from 8 to 15 months. And during this time, you see your assets usually will be frozen and until at least an accurate inventory can be taken. Again, this may take some time. Also, nothing can be distributed or sold without the permission of the executor, and sometimes the permission of a judge is required. And oh, by the way, if the estate includes any illiquid assets, maybe real estate or an operating business, it's going to take longer than 15 months typically. In fact, if you were to look at the current probate matters in my office right now, we've got a number that are well beyond 15 months. Problem number 2, cost. Probate is expensive, and by far the largest expense involves the fact that, at least in Florida now, a lawyer must be involved in most every probate, where the executor is required to hire a lawyer to handle it. So again, in most every probate, the heirs cannot sort of handle that probate themselves, even if they want to. And that same law that requires the use of a lawyer sets the lawyer's fee. It's a percentage-based fee based on the value of the estate. It's between 3 and 5% as a fee that goes to the lawyer. And that is a big ouch. So problem number 2, it's expensive. Problem number 3 with probate is a lack of privacy. Probate is not private. In fact, it is very public. Probate, it's a legal process that requires the legal filings in a public court record. And if the deceased person had a will, that will is also filed with the court for anyone to see. Your life story, your family wishes on public display. And all someone has to do is, drive down to the courthouse to look at the will. Oh, wait a minute. No, they don't have to drive down to the courthouse anymore. They can, with a few keystrokes, pull it up very quickly in the comfort of their living room. And, a lot of people don't like that. They don't like the idea that their nosy friends or family members can see what they left behind and who they're giving it to. So that's problem number 3, is lack of privacy. And problem number 4, lack of control. Since the probate process is regulated by court proceedings, your executor is going to have to request court permission to administer certain assets, like real property. So many potential buyers, frankly, are hesitant to purchase homes that are going through probate. Why? Because it can take months before the court's going to grant that executor the permission to sell the property. And families are really accustomed to handling their affairs privately and independently, and now suddenly they have lost control to a legal process, and they have to pay for it on top of that. That can be frustrating. So if you want your loved ones to have more flexibility and control after your death, it is best to have things administered outside of the probate process. And again, a living trust often is the best answer, a great alternative to a will. So if you'd like to know a little bit more about, what probate is and how bad it is, and maybe how we can help, we'd love to talk to you. So we invite you to schedule a free 15-minute phone call. And the scheduling is very easy. Just go to the link in this video, click on it, and it takes you straight to our booking calendar. Or if you want to go to our website, Legacy Planning Law Group, and select the, your schedule your free discovery call, gets you to the same place, pick a day and time that works for you. If you've enjoyed this video, please like and share with your friends, and subscribe to our YouTube channel if you haven't already done so. So this is Bill O'Leary for now. And what I'd like you to do is go make it a great day and a better world.